Hi friends, I am Prof.N.S.Syama Prasad. I am to give a lecture on Supreme Court of India. Main thing is about the independence of the Supreme Court of India, how the Supreme Court of India is made independent by the Constitution of India. Our Supreme Court was formally inaugurated on 28th January 1950. Before that, we had a Federal Court of India that was created by the Government of India Act of 1935. And as per the new Constitution, the Supreme Court was established on 20th January 1950. And at that time, there were 8 judges, including the Chief Justice. The first Chief Justice of India was Harilal J. Kania. So Harilal J. Kania and 7 judges were there, total 8 judges. Now the number has gone up. Parliament has the power to increase the number of judges, and at present there is the Chief Justice and 33 judges. Total 34 judges are there in the Supreme Court of India. And the Supreme Court must be independent, High Court must be independent, because if these courts are not independent, the people will not get justice. Suppose I am filing a case against central government in the Supreme Court, and if the Supreme Court is not independent, I will not get justice. Therefore, the constitution makers have taken necessary safeguards to protect the independence of Supreme Court, High Courts, etc. These two are the very important courts of India. I shall give you an idea how the judiciary is organized in India. It has a hierarchical structure. At the top, there is a Supreme Court of India. Next level, we have High Courts. There are 25 High Courts in India. Next level, district courts are there. Below the district courts, there are sub-courts, and below the sub-courts, there are municipal courts and magistrate court. This is the organized judiciary, that's a hierarchy organization. And you can see, from the lowest court, you can go to the highest court of India. And there are 2 Supreme Courts, which are very powerful. One is the Indian Supreme Court, and the other is the American Supreme Court. But nowadays, we can definitely say that Indian Supreme Court is more powerful than the Supreme Court of America, because our Supreme Court is given vast powers, and by self-enlargement of power, the Supreme Court has increased its power. Therefore, now Indian Supreme Court is the most powerful Supreme Court in the world. Now we shall discuss how the Supreme Court is made independent. Constitution has made a number of provisions to make the judges independent. First thing, the qualification. We have fixed very high qualification for judges of Supreme Court. The President appoints the judges of Supreme Court, but they are appointed on the recommendation of Collegium. The Collegium is a 5-member body that is run by the Chief Justice. The Chief Justice and 4 senior-most judges. They will select the judges to be appointed in Supreme Court, and they will be appointed by the President. So, President appointing the judges, Executive appointing the judicial members. That is the best method, because if a judge is selected by the people, or if the judge is selected by members of parliament, that judge cannot be independent. The best method is, therefore, the President should appoint the judges. Second thing, high qualification. First thing, he must be a citizen of India. Second, he must have been a judge of High Court for at least 5 years, or advocate of High Court for at least 10 years, or he must be, in the opinion of the President, a distinguished jurist. So, most often we see High Court judges are promoted and posted as Supreme Court judges. You are a judge of High Court for 5 years, or you are an advocate of High Court or Supreme Court for 10 years. Everyone knows whether you are able, whether you are capable, whether you are thorough with the law, thorough with the constitution, etc. On that basis, you can be appointed. So, we have prescribed very high qualification for appointment as judges. But you may see, no distinguished jurist has been so far appointed as a judge of the Supreme Court. And out of 100 members, normally you can see 90-95% will be appointed from the High Court, from the bench, and about 5 or 10% will be appointed from the bar. That is the method of appointment. Second is, to protect the independence of judges, the salary and service conditions are well prescribed, well protected. Supreme Court judges are given high salary. You may see that the Chief Justice of India gets 2.8 lakhs rupees per month, and judges of Supreme Court get 2.5 lakhs rupees per month. And this is charged upon the Consolidated Fund of India. Charged upon means the Parliament need not pass this amount in the budget. It's a non-votable item in the budget. Parliament has no power to withhold salary of judges. Even if decisions of the judges are against the members of Parliament or against the government, the salary cannot be withheld. Parliament has no power to withhold the salary. That is why we say it is charged upon the Consolidated Fund of India. And Parliament has no power to, or the government has no power to reduce the salary of judges. Once appointed, the salary cannot be reduced. The government can only increase the salary. And you can see there is only one occasion when the salaries of the judges can be reduced, when there is a financial emergency proclamation in operation, the salaries can be reduced. Otherwise, government has no power to reduce salary, government can only increase salary. Similarly, Parliament has no power to reduce the power of the Supreme Court, Parliament has the power to increase the power of the Supreme Court, it can reduce the power of the Supreme Court. That is also a measure to protect the independence of judiciary. Another is service conditions. The service conditions of judges are well protected. You know, once a Supreme Court judge is appointed, he can continue until he attains age of 65. 65 years, that is the retirement age. Normally he cannot be removed earlier. And suppose there are allegations, for example, on the ground of proved misbehavior or incapacity, a judge can be removed from service. That is generally known as impeachment. Actually, Indian court uses the word impeachment only for the removal of judges, or only for the removal of president, but some days for the removal of judges also use the term impeachment. And there is a law, Judges Inquiry Act 1968. What that says, the procedure of impeachment of the judges of Supreme Court and High Court. If a judge of the Supreme Court is to be removed, first of all, a notice should be given to the Speaker or to the Vice President. If it is given to Speaker of Lok Sabha, that should be signed by 100 members to the Lok Sabha. And if the notice is given to the Vice President, that should be signed by 50 members of the Rajya Sabha. On the receipt of this notice, the Speaker or the Vice President may appoint a High Court committee consisting of the Chief Justice of India or Senior Most Judge of the Supreme Court, a Chief Justice of the High Court, and an eminent jurist. This committee will go into allegations, and if the committee finds the allegations are true and further action can be taken, then the impeachment proceedings can be taken in the Parliament. In both, if it is passed by one house, it is in the other house. If the other house also passes a resolution, the President can remove the judge. No judge has been so far impeached. We have tried to remove two judges. One, Justice Ramaswamy, and the other, Justice Syama Prasad. Both failed miserably. Anyway, there is a provision that a judge can be removed for proved misbehavior or incapacity. Normally, they can continue until they attain just 65. Next, another protection is that a judge of Supreme Court after retirement cannot practice as an advocate in any of the courts of India. A Supreme Court judge after retirement cannot practice as an advocate in any of the courts in India. That is also to protect the independence of the judges. But they can hold assignments. There will be a number of assignments reserved for retired judges. You can see, some days retired judges are appointed as governors. They can be appointed as chairman of Human Rights Commission, Law Commission, etc. So many assignments are waiting for them. Only bar is that they can practice as advocates in any of the courts in India. Then another important thing is, formerly the Chief Justice was appointed by the Cabinet and the decision was taken by the Prime Minister and the Ministers. Sometimes seniority was overlooked and sometimes juniors are appointed as Chief Justice. When a junior is appointed as Chief Justice, the seniors will naturally resign and go. This has happened on two occasions. Now Supreme Court has given a direction that the senior most judge of the Supreme Court should be definitely appointed Chief Justice of India. No other consideration can be there. So now, if you go into the list of judges of Supreme Court, we can say who will be the Chief Justice in 2026 will be the Chief Justice in 2026-7 because purely on the basis of seniority, the Chief Justice can be appointed. There was a report recently, and the Justice V.V. Nagartna from Karnataka will be the first woman Chief Justice of India. She will be appointed Chief Justice in 2027 because everything is done on the basis of seniority in the Supreme Court. Then another important thing is no criticism of the judgment of the judges can be done in the Parliament. Parliament words, ministers have no right to criticize the judges or judgments. Similarly, we have passed an act called Contempt of Court Act. 1971, we have passed an act called Contempt of Court Act. Contempt of Court Act says the order of the Supreme Court or the High Court must be obeyed by everybody. Nobody can criticize the judgments given by these courts. If anybody criticizes the judgment, if anybody disobeys the orders of the court, contempt of court case can be taken against them. And the maximum punishment for contempt of court is 6 months simple imprisonment and or a fine of rupees to 2,000. So nobody can criticize judgment, nobody can criticize judges, and their independence is well protected. Then another important thing is the staff of the Supreme Court. Every official of the Supreme Court will be appointed by the Chief Justice. Their salary and service conditions will be decided by the Chief Justice. They are completely free, insulated from the control of the government. Government has no control over the officials of the Supreme Court. Everything is decided by the Supreme Court itself. And the expense of the office of the Supreme Court will also be charged upon the controlled fund of India. That means nobody has any power to control or limit the power of the Supreme Court. Now, another important point we must see, as I told you earlier, 2 or 3 reasons can be cited why Indian Supreme Court is more powerful than the American Supreme Court. One important factor is that Indian Supreme Court can look into the matters of 140 crores of people, whereas American Supreme Court is concerned only with about 40 crores of people. Another important thing is, from the lowest court we can go to the highest court. But in America, state cases will enter the state level, they cannot be taken to the Supreme Court. Now the third reason is that in the line of president succession, is a president dies or is removed, vice president will become the president of India. And if the vice president is not there, Chief Justice of India will become the acting president. That is, we have seen Justice Hidayatullah became the acting president when Zakir Hussain died and B.B. Giri resigned. Third chance was given to Justice Hidayatullah. But in America, there is no such system. Then another reason is that basic structure theory. Supreme Court has developed a basic structure theory, and that has increased the powers of the Supreme Court. Then one more thing, collegium. Collegium is an extra constitutional device, extra legal device by which the Supreme Court has got a very important power. It has the power to select the judges of Supreme Court and High Court. Judges selecting judges, if practice a practice followed only in India. This is the Supreme Court of India has become more powerful than the Supreme Court of America. So these are the points you must remember about the independence of the Supreme Court of India.